So one of the things that is a little bit surprising to a lot of people about divorce in Connecticut is there's actually still a for-fault divorce option. Most people think, it's the modern era, right? There's only no-fault divorce, but that's not actually the case. We have both kinds here in Connecticut. Now, that said, even though we have both kinds, the vast majority of divorces, I'm talking about like 99% of divorces, are actually what we call no-fault divorces. The question is, what actually is a no-fault divorce? Because I think that the name understandably confuses a lot of people. So if you think about the term no-fault divorce, it implies that no one did anything wrong, right? We were both perfect angels and we were just making a different decision and ending the marriage. It's not really what a no-fault divorce is. A no-fault divorce or a fault divorce refers to what you actually have to prove in order for a Connecticut judge to allow you to get divorced, to grant your divorce. So in other words, a no-fault divorce doesn't mean two perfect angels, no one did anything wrong. What it means is that in order for a court to grant your divorce, the only thing that you have to prove is that your marriage has broken down with no hope of reconciliation. So in other words, by one person saying, we're not going to get back together and we're not going to get back together in the future, that's enough for a Connecticut judge to actually grant a divorce. You can see why no-fault divorce is so popular, right? You don't have to prove anything like adultery, like abandonment. All you have to do is say, I'm confirming that this marriage has broken down and we're not going to get back together. All right, so Connecticut has a kind of unique asset division structure. And the reason I mention that is because there are a lot of things out there in the ether about how property gets divided in divorces. And something that you might read on the internet might be very true in one state and just not the case in Connecticut. So let's take a little bit of time and talk about how it actually works in Connecticut. So the first thing that we do is we divide property equitably. What's that mean? Well, when I explain what it means, I like to start by explaining what it doesn't mean. It does not mean 50-50. Some states, property gets divided 50-50. In Connecticut, nope, equitably. What's that mean? Well, when you work with an experienced divorce attorney like our team here at Marcroft, they have a sense of how the different judges in the different courts in Connecticut tend to view different circumstances. For example, does one spouse work outside the home and the other spouse is the primary caregiver for the children? Is it a long marriage? Does someone have significant health concerns? All of these types of factors are what lawyers call them. They play into what a court might view as equitable when they're looking to decide how to divide property. The very best advice I can give you, and look, I'm a lawyer. I know this sounds self-interested, but the very best advice I can give you is talk to a really experienced lawyer who practices Connecticut family law, who knows the judges in the courtroom you're going to be in, and you'll get the best take on how things might go in a case like yours. Now, that all said, if I stress one thing about why a lawyer is so important on property division during your divorce. Property division, how assets get divided, that's the hardest thing for lawyers to clean up if you get it wrong the first time. So for example, you get divorced. You use a lawyer who's a family friend who's not a very experienced family law practitioner. You had a lawyer, good job. The problem is that if they aren't really good at maximizing property division and understanding how we can do that in Connecticut, and later you want to try and fix it, it's hard to unring the bell on property division. The best money that you can spend when it comes to maximizing how assets get divided in a divorce is to work with a really experienced attorney as soon as possible. Like, the first best time is before you file for divorce. The second best time is as soon as you watch this video. So usually we think of things like if there's a longer term marriage, like a 10-year marriage, a 15, 20, 30-year marriage, then we expect to see the division of assets come in somewhere around 50-50, 60-40, somewhere in that range. But what if someone winds up getting a significant amount of alimony in exchange for taking less of the property? Or what if one of the spouses has a significant inheritance that they've just received? Or what if something happens where someone has a disability that needs to get addressed so that both spouses are financially stable on the other side of the divorce? That's why, even though, most divorces come in around 60-40, there are also one thing can happen, a couple of things can happen, and that just makes that an unrealistic outcome for the person in those circumstances. So the plot here, the takeaway is talk to a lawyer, give them as much information as you can about your circumstances and your spouse's circumstances. Be super candid because you want the best information you can get coming out of that conversation. And that's the path to finding out the sort of best case range in your case. The fact that there's not crystal clear guidelines or rules about how property gets divided in Connecticut, even though it seems frustrating at first, is actually a tremendous opportunity. So let me explain a little bit about why. We can get a lot more creative about how to divide things. Sometimes for one spouse, it makes sense to have a lot more of the retirement assets for some reason. In other cases, maybe someone wants to keep more of the family business. It's not a straight 50-50 down the line on every given asset. We can trade and try and make things holistically make more sense for both spouses. Essentially expand the pie, sharing the assets in a way that delivers the most value to our client. Another thing that's really important to know when you think about asset division is in Connecticut, because there's no hard and fast rules, there can also be a trade-off between things like alimony, which some people call spousal support, so like a weekly, a monthly check. There can be a trade-off between that spousal support and how property is divided. So but depending on our client's circumstances, we might make a strategy to advocate for a holistic package that's most in line with their goals for their future, because that's ultimately what matters most to us, not 50-50 of every single asset down the line or 60-40 or whatever the number is. It's delivering what is holistically going to set them up for the future. So alimony, there's a consistent thing in Connecticut, not a lot of hard and fast rules. So alimony, like property division, also has a series of factors that courts look at on on whether or how there will be alimony. Because one of the things that's important to know about alimony is that there's not alimony in every case. So how do you know whether there might be alimony in your case? Whether you might pay it, whether you might receive it, what the odds are of that, how a court is likely to look at it. And the best advice that I can give on that is to meet with an experienced divorce lawyer so that you can really get a sense of whether your case is an alimony case, and if so, what that might look like. Another situation with alimony, like with property division, is that it's highly fact specific. It really depends on a lot of the circumstances of each of the two individuals that are in the marriage. Their ages, what they do for work, their occupations, their health, their prospects to earn more in the future, whether or not they're engaged in further education to get back into the workforce. All of these things are weighed. And a lawyer who's got a lot of background working with people and working in the Connecticut courts can give you a good sense of where you might fall.